A lawyer just looked at the Supreme Court's latest gun moves and said the ground under your feet is shifting again, and if you own a gun, carry a gun, build a gun, or even travel with one, what changed in the last few months could affect you a lot faster than you think. Quick question before we continue, are you subscribed? Because what I'm about to reveal could keep you from making a mistake that turns a normal day, a normal carry trip, or a normal range visit into a legal nightmare. Hit that button now. Here's what just happened. A lot of people think one big gun case changed everything. That is not what happened. The real story is bigger. This court made a series of moves that hit gun rights from different angles, and when you put them together, the whole legal map starts to look different. First, the court narrowed the federal gun ban on people who use illegal drugs. Then it struck down Hawaii's rule that treated many public-facing private businesses like automatic gun-free zones. Then, not long before that, it upheld federal regulation of at least some ghost gun kits and unfinished frames. And then the court agreed to hear major cases over assault weapon bans, including bans covering AR-15 style rifles. That is why lawyers are sounding the alarm. Not because one sentence changed everything overnight, but because the court just sent signals on who can be disarmed, where you can carry, what the government can regulate, and what giant fight is coming next. Let me explain why this matters to you. Most people think gun rights only change when a final ruling comes down in one blockbuster case. But the truth is messier. The fight changes when the court accepts a case. It changes when lower courts read a decision differently. It changes when lawmakers think they have cover to push harder. And it changes when regular gun owners hear half the story online and make choices based on bad advice. That is the real danger. Confusion hits before clarity does, and confusion is where normal people get trapped. First thing, let's talk about the drug user case, because this is where a lot of people miss the biggest signal. In June 2026, the Supreme Court narrowed the federal ban on gun possession by people who use illegal drugs. In simple English, the court said the government cannot just point to drug use by itself and automatically win. The government needs more. It needs evidence showing the person is actually dangerous. That is a huge shift in how the court is looking at blanket bans. Most people think this only matters if they use drugs, but the truth is bigger. It shows the court is asking harder questions when the government tries to ban a whole group of people from gun possession without showing a real danger. Now, this is where it gets interesting. Think about what that means for other gun cases. If the government cannot just say you are in this category, so you lose your rights, then every other broad ban starts getting looked at harder too. That does not mean every ban dies tomorrow. It means the government may have to work much harder to justify one, and that is a very different battlefield from what many lower courts were used to. Second, let's talk about Hawaii. In June 2026, the Supreme Court struck down a Hawaii law that treated private property open to the public like stores and restaurants as off-limits for guns unless the owner gave express permission. In plain English, Hawaii tried to flip the default rule. Instead of carry being allowed unless the owner said no, the state tried to make carry banned unless the owner said yes. The court said that went too far. Why does that matter to you? Because a lot of anti-gun states have been trying to do something very similar since Bruen. They lose on permits, then they try to win by making almost every place off limits. Here's the part nobody's talking about. A lot of states learned they could not just ban carry in a simple way after Bruen, so they started slicing the map into tiny no-carry zones: parks, buses, museums, hospitals, bars, restaurants, public gatherings, private businesses open to the public. Piece by piece, they tried to turn your carry right into a paper right, something you technically have but can almost never use. The Hawaii ruling matters because it tells states they cannot play that game without real historical support. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now let's talk about the ghost gun ruling, because this is where many gun owners got surprised. In March 2025, the Supreme Court upheld federal regulation of at least some ghost gun kits and unfinished frames. In simple English, the court said the federal gun law can cover at least some kits and parts that are easy to turn into working firearms. That means the government can require things like serial numbers, background checks, and records for some of those items. So on one hand, the court narrowed one federal gun ban. On another hand, it upheld one major federal gun regulation. That is why simple slogans fail here. Most people think the court is either fully pro-gun or fully anti-gun in every case. That is not how this works. The truth is the court has been drawing lines. If a regulation looks too broad and not tied to real danger, the court may hit it hard. If a regulation fits inside an existing federal law and targets a different problem, like untraceable kits sold outside the normal rules, the court may let it stand. That means you cannot just hear good court or bad court and stop thinking. You have to ask what exact question the court answered. Let me break this down for you with a real-world example. Imagine two gun owners. One owns a regular carry pistol and worries about whether he can legally carry it into a restaurant or store in a restrictive state. The Hawaii case may matter to him a lot. Another person likes building guns from kits and thinks unfinished parts are outside federal rules. The ghost gun case may hit that person much harder. Same court, same constitution, totally different answers based on the exact legal problem in front of the justices. And then came the move that really made lawyers lean forward. On June 30, 2026, the Supreme Court agreed to hear two major challenges to assault weapon bans, one from Cook County, Illinois, and one from Connecticut. These cases ask whether the Second Amendment protects AR-15-style rifles and similar semi-automatic weapons. That is a giant question, because if the court says these bans are unconstitutional, it could shake similar laws in about a dozen states and some cities and counties. And if the court upholds them, anti-gun lawmakers everywhere will feel stronger. Here's what most people get wrong. They think the fight is only about AR-15s. It is not. The real fight is about how the court views common firearms in general. Since Heller in 2008, the court has said weapons in common use for lawful purposes are protected. Then in Bruen in 2022, the court said modern gun restrictions need to fit with the nation's historical tradition of firearm regulation. Those two ideas are now crashing into modern bans on semi-automatic rifles. Are AR-15-style rifles common and lawful? Millions of owners say yes. Are they protected even if lawmakers call them especially dangerous? That is the fight. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group, join the gun owners who get these updates first. Click subscribe. Now let me explain why this feels like gun rights changed forever, even before the AR-15 cases are decided. The answer is not just one ruling, it is the pattern. The court is forcing the government to justify gun laws in a very different way than many states want. After Bruen, the government cannot just say, this law seems smart, so it should stand. It has to point to history. It has to show a tradition. It has to explain why the law fits with what the Second Amendment allows, that shifts power away from simple public policy arguments and toward historical proof. That is a huge long-term change. But here's the crazy part. That same history test is also messy. Lower courts have struggled with it. Some judges read history broadly. Some read it narrowly. Some find old analogies everywhere. Others say those analogies are weak. That is why you keep seeing a weird mix of results. One court upholds a ban, another narrows one, another strikes one down, another says the government can still regulate this other category. Two regular gun owners, it feels chaotic. Two lawyers, it feels like a system still fighting over the rules of the game. This is the part that shocked me. Many people heard Bruen and thought, okay, gun rights won, we're done. But what really happened is Bruen opened the gate 2 years of new fights. Since then, courts have been flooded with challenges to all kinds of gun laws. Carry laws, possession bans, sensitive place rules, semi-automatic rifle bans, magazine limits, ghost gun rules, you name it. So when someone says this court changed gun rights forever, that is true in one very important sense. The old way of judging gun laws is gone, and the new way is still being fought over case by case. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. That matters because your real risk depends on where you live, what you own, where you carry, and what rule is being challenged. One state may be pushing new carry limits right now. Another may be waiting to see what happens in the AR-15 cases. Another may already have broad bans in place. Another may focus on part skits or private property carry rules. So if you rely on one viral headline, you can still walk yourself into serious trouble. Then your state passed a rule trying to make almost every private business a no-carry zone by default. The Hawaii case suddenly matters to you, or imagine you use marijuana in a state where it is legal under state law but still illegal under federal law. You think your gun rights disappeared automatically. The Hemani case may matter to you more than you realize, or imagine you own an AR-15 and live in a state with a current ban, or you are thinking of moving to one. The cases the court just took may matter to your safe, your travel plans, and maybe your future ownership rights. Most people think these are separate stories. The truth is they are connected. The court is showing us how it thinks about gun rights in 4 different lanes. Who can be disarmed, where you can carry, what the government can regulate in the gun market, and whether common semi-automatic rifles can be banned. That is why the whole picture matters more than any one clip on social media. Here is what you should do right now if you care about staying legal. First, know your state's current law, not the law you wish you had. Second, if you carry, check private property rules in your state and any state you travel into. Third, if you build guns or buy part skits, stop assuming unfinished means unregulated. Fourth, if you own an R-15 style rifle, watch the Supreme Court calendar closely because the next term could bring one of the biggest Second Amendment rulings in years. Fifth, stop trusting maps with no dates on them. Laws move fast, court. Orders move faster than most people think. Have you ever wondered why two gun owners can hear the same court news and walk away with totally different opinions? One says, this is a total win. Another says, this is a total disaster. Most of the time, both are reacting to only one corner of the story. The smarter move is to step back and ask, what exact power did the court just limit, and what exact power did it just leave in place? That is how you stay grounded. Here's a hypothetical example to explain this. Let's say your cousin hears the court narrowed the federal ban on unlawful drug users and says, see, the court is wiping out all gun restrictions. That is wrong. Then your neighbor hears the court upheld regulation of some ghost gun kits and says, see, the court is going anti-gun now. That is also wrong. The truth is, the court is not giving one simple answer to every gun case. It is making the government prove its case in a different way, and that means some laws may fall while others survive. This is where it gets even bigger. The R-15 cases the court just accepted may become the next huge marker. If the court says R-15 style rifles are protected because they are in common lawful use, that could hit bans across the country hard. If the court says states can still ban them as especially dangerous, then a major line will be drawn against one of the most common rifles in America. Either way, that answer will shape gun politics, gun litigation, and gun ownership for years. This information could literally expire after the next round of Supreme Court briefing and arguments. Subscribe now because the next video explains exactly what you need to do before that deadline pressure hits. So here's the key takeaway. This court did not just change one gun rule. It changed the whole fight over gun rights by forcing new questions about who can be banned, where you can carry, what can be regulated, and whether common semi-automatic rifles are protected. That is why lawyers are saying the game changed forever. If you own guns, carry guns, build guns, or just care about your rights, do not treat this like background noise. Stay informed, check your state, watch the next Supreme Court term closely. And remember, this video is for education only, not legal advice, so always talk to a qualified attorney about your specific facts before you make a move. And if you want to stay ahead of the next ruling instead of hearing about it too late, subscribe now and stick with me.